I'd like to hand over to Maureen O'Hara.
I'm going to talk about policies and practice within the criminal justice system in England and Wales, which classify and treat suspects and defendants in criminal trials on the basis of their gender identity rather than their sex. The reason I'm focusing on England and Wales is because law and policy in other parts of the UK are different in some ways. I'll focus particularly on the practices of the police, the Crown Prosecution Service, who bring prosecutions on behalf of the state in England and Wales, and the courts, in relation to males who are alleged to have committed or have been found guilty of committing sexual or violent offences and who identify as transgender. I don't have the time today to talk about prison service policy, which also treats offenders on the basis of their self-defined gender identity now, and houses some trans-identifying males in women's prisons. That is also a very important part of what is happening in the criminal justice system now in England and Wales. Many police services now record suspects and convicted offenders on the basis of their self-defined gender identity rather than their sex. The Crown Prosecution Service has a national policy of recording suspects and defendants on the basis of gender identity and of referring to them using their preferred pronouns in court when they're prosecuting. Guidance for judges on the treatment of witnesses at court, which is contained in a book called the Equal Treatment Bench Book, or the Bench Book, generally adopts the same approach. It's published by the Judicial College, which carries out training for judges on behalf of the Lord Chief Justice, who's the leading judge in this jurisdiction. I'm going to start by talking about the Bench Book because it was amended in December 2012 in a way which takes account of some of the criticisms that were made of earlier versions by gender critical feminists and by lawyers. And then I'll talk about the ways in which these positive amendments are undermined by other criminal justice practices. And the amendments relate to the compulsion on witnesses in criminal trials and in civil hearings as well to use the preferred pronouns of trans-identifying defendants or others involved in the proceedings. These are excerpts from previous versions of the Bench Book. The one published in March 2020 said, showing respect for a person's gender identity includes using appropriate terms of address, Mr., Mrs., Miss, pronouns and possessives. Non-binary people may prefer to be referred to in gender neutral terms, e.g. mux, they and their. And whilst gender neutral terminology is not yet mainstream, this should be accommodated wherever possible. When I first read this, I was amazed that this was in guidance for judges, especially the part about non-binary and calling people mux in court. And I assumed, and I think it's probably the case, that this was not written by judges, it was written by a trans lobby group. That was toned down in the next edition to some extent, which said it's important to respect a person's gender identity by using appropriate terms of address, names and pronouns. Everyone is entitled to respect for their gender identity, private life and personal dignity. Some judges interpreted the guidance to mean that they had to try to compel all witnesses to use the preferred pronouns of trans-identified males who were defendants, who were parties in proceedings in other contexts. And that had particularly serious implications for witnesses who were giving evidence about their experiences of physical and sexual violence. Previous versions of the Bench Book didn't address the impact on these witnesses of being required to describe a defendant in criminal proceedings or an alleged perpetrator of domestic abuse in family proceedings in ways which amounted to a denial of their own perceptions of reality. This account of being instructed by a judge to use a defendant's preferred pronouns was given by Maria McLaughlin, who was assaulted in 2017 by a group of trans activists. One of her attackers, Tara Wolf, who was the only one who was prosecuted, who self-defined as trans, was convicted of assault by beating in April 2018. At court, the judge insisted that Maria should use Wolf's preferred pronouns and refer to him as either she or the defendant. And she said about that, my experience of court was much worse than the assault. I was asked, as a matter of courtesy, to refer to my assailant as either she or the defendant. I've never been able to think of any of my assailants as women because at the time of the assault, they all looked and behaved very much like men. And I had no idea any of them identified as women. I tried to refer to him as the defendant, but using a noun instead of a pronoun is an unnatural way to speak. It was while I was having to relive the assault and answer questions about it while watching it on video that I skipped back to using he and earned a rebuke from the judge. I responded that I thought of the defendant, who is male, as a male. The judge never explained why I was expected to be courteous to the person who had assaulted me, or why I wasn't allowed to narrate what had happened from my own perspective, given that I was under oath. Since Maria's case, and also since the decision in the lower courts in the case of Forstater and CGT, which I'll talk about a bit later, in which the judge relied on the bench book almost as if it were law and not simply guidance, there's been increasing criticism of the bench book, both by feminists and by gender critical lawyers. Most criticisms are related to broadly 4 areas. Firstly, the compulsion in relation to the use of preferred pronouns and modes of address of trans-identifying parties in court proceedings. Secondly, the adoption of the tenets of gender identity ideology as if it were fact, or as if they were facts. Thirdly, the implementation of self-definition of gender identity in court proceedings, despite the fact that self-definition of gender identity is not law in this jurisdiction. Somebody cannot legally change sex in this jurisdiction by self-definition only. And fourthly, the lack of transparency about who contributes to the bench book. In August 2021, a group of practicing lawyers and legal academics wrote to the Lord Chief Justice expressing concerns about the previous versions of the bench book. The Lord Chief Justice passed our letter onto the bench book's editorial panel for consideration, which we were very surprised about at the time. And the revised version of the bench book has taken on board some of the comments we made and some of the criticisms that we raised in our letter, particularly in relation to the treatment at court of witnesses giving evidence about their experiences of sexual violence and domestic abuse. And in December 2021, a new revised edition of the bench book was issued, which included significant amendments in relation to those witnesses. The revised bench book recognises for the first time that witnesses have a right to refer to trans-identifying people using pronouns which align with their sex, at least in some circumstances, and acknowledges that there may be circumstances where this is required by the interests of justice, which is a major step forward. This is from the revised guidance, and it says there may be situations where the rights of a witness to refer to a trans person by pronouns matching their gender assigned at birth, or to otherwise reveal a person's trans status, clash with the trans person's rights to privacy. It's important to identify such potential difficulties in advance, preferably at a case management stage. That's a meeting that takes place before the hearing itself to sort out issues like this. But otherwise, at the outset of the hearing, a decision would then have to be made regarding how to proceed, bearing in mind factors such as why the witness is unwilling or unable to give evidence in a way which maintains the trans person's privacy. For example, a victim of domestic abuse or sexual violence at the hands of a trans person may understandably describe the alleged perpetrator and use pronouns consistent with their gender assigned at birth, because that is in accordance with the victim's experience and perceptions of the events. Artificial steps such as requiring a victim to modify his or her language to disguise this risks interfering with his or her ability to give evidence of a traumatic event. There will be occasions when, after these and other relevant factors have been considered, the interests of justice require that a witness or party may refer to the trans person using their former pronouns or name. So this amendment should mean that complainants giving evidence in trials for rape or other sexual offences will not be compelled to call male defendants she, and that women giving evidence in family proceedings about their experiences of domestic abuse will not be compelled to call their former male partners or describe their former male partners as if they were a woman. And the fact that the amendment uses the language of rights is significant, although it's not fully a right because the court still has to agree to it. It's not something someone will be permitted to do automatically, to use sex-based pronouns and modes of address instead of those of the person's so-called gender identity. So while this is an important step forward, many of the problems raised by the bench book's general guidance about the use of preferred pronouns are not addressed in the new version. In practice, witnesses' ability to exercise their right to use pronouns which align with the sex of trans-identified parties in proceedings will be limited by the fact that the guidance is likely to be interpreted to mean that the judge, the lawyers representing all the parties in the proceedings, and possibly the other witnesses, should use preferred pronouns based on self-defined gender identity. And the guidance doesn't discuss the implications for a witness of calling a trans-identified male he in court, while everyone else who speaks in the courtroom refers to him as she. Where this happens, it's likely to confuse and unnerve the witness, who may feel pressurized to use preferred pronouns themselves. And that experience is likely to be compounded and be particularly confusing and distressing for child witnesses and witnesses with learning disability, who won't understand the concept of gender identity necessarily and how it differs from sex. In criminal proceedings, this problem is likely to be compounded in cases where witnesses have already experienced the local police service and the Crown Prosecution Service referring to trans-identified defendants according to their gender identity rather than their sex. Current police guidance states that where there is doubt as to whether a person should be treated as male or female, that person should be asked to indicate their preference and treated in accordance with that preference, except where there are grounds to doubt that the expressed preference accurately reflects the person's predominant lifestyle. So if the police discover that a man who says he's a woman and wants to be called she has not in the recent past been living as a woman as they would see it, which means wearing female clothing, using a female name, using female pronouns and so on, they might decide that the expressed preference is not a genuine one and it's just for the purposes of the investigation and not use the preferred pronouns and so on when recording their identity. But other than that, they are expected to record them as she if they ask to be recorded as she, and that's not just for the initial recording. That recording will continue if they are convicted. That's from police guidance and codes of practice, and this is from research carried out by the gender critical campaigning group Fair Play for Women, which they published in 2021. They sent freedom of information requests to all the police services in England and Wales. That's requests which they're obliged to respond to, asking them about their policy. Not all of the police services responded. 16 services stated that they recorded the sex of suspects and convicted offenders on the basis of their self-identified gender. Of these 16, one made an exception where the suspect was charged with rape, in which case they would record them as male. In this jurisdiction, rape is an offence which can only be committed by a male because it involves a penetration of another person with the penis without their consent. So it cannot be committed by anyone but a male. But nevertheless, 8 services confirmed in answer to a specific question relating to the offence of rape that they would record the sex of a rape suspect who identifies as transgender as female. Asked whether they would also make a separate record of the fact that the suspect was transgender for data collection purposes, most of them said they wouldn't do so unless the suspect was thought to be a victim of a hate crime as a result of their trans status. So that's the police are the first point of reporting an offence. They are using pronouns and recording information based on gender identity, and so are the Crown Prosecution Service. Their National Trans Equality Statement says, prosecutors should address trans victims, witnesses and defendants according to their affirmed gender and name, using that gender and related pronouns in all documentation and in the courtroom. And this is an example of the use of preferred pronouns in the courtroom. In 2018, Karen White, a trans-identifying male, was convicted of 2 rapes and of other sexual offences against women. And the prosecutor at White's trial was reported in the press as referring to White in the following way. Her penis was erect and sticking out of the top of her trousers. And this is now becoming standard practice in the courtroom. When prosecution and defence lawyers describe males in this way in court, they're effectively denying the reality of witnesses who've experienced male violence and undermining their ability to accurately describe their experiences at court. And that remains a problem despite the amendments to the bench book. Because if the prosecutor and the defence, which the defence will certainly be talking like this, question a witness using the preferred pronouns of the trans-identifying defendant, it's going to be very difficult for them to maintain the use of he and his. In addition, the revised version of the bench book continues to use language founded in gender identity ideology, such as gender assigned at birth, as you'll have seen from the quotations. Their introduction of self-definition of gender identity happened without public consultation, and the process by which the bench book guidance is developed is not open to public scrutiny. The Judicial College have refused to disclose who's involved in it. The same is true of the introduction of self-declaration of gender identity by the police and the CPS. It's not the law. It hasn't been introduced into the criminal justice system by law, it's been introduced by a process of policy capture. So as I said, the Judicial College has refused to say who's involved in the production of the bench book. The fact that the panel did consider our letter to the Lord Chief Justice and did amend the bench book to take account of some of its concerns is encouraging. It's an encouraging sign of an increasing openness to a wider range of opinion. And that, I think, is because of the success recently of gender critical campaigns in England and Wales, and also the rest of the UK. And also as the result of cases such as that of Forstata and CGD, which on appeal led to a decision that gender critical beliefs are protected under the Equality Act, which is a very significant decision for our ability to continue to campaign against gender identity ideology. I think a lot of the cases that have taken place, as well as the campaigning, have changed public discourse around the conflict between women's sex-based rights and gender identity ideology, and that some important gains have been made. But there's still a very long way to go before the policy capture of criminal justice agencies can be undone, so that male suspects defendants and offenders are recorded and described according to their sex and treated according to their sex, for example, in prison, and not according to their claimed gender identity.